Good evening. I am Edgar C. TADEO Jr., and this is my video recitation on my subject in the philosophy of law under Attorney Eric Aguilar. My report shall delve on the case of Bauer v. Hardwick, which was decided by the Supreme Court of the United States on June 30, 1986. It is one of the most famous, or rather infamous, cases that was decided by the U.S. Supreme Court. We shall find out why as we proceed with the presentation. Right, so we now go to the facts of the case. So this is a case about Michael Hardwick. Michael Hardwick is a bartender that works in Georgia. He is a member of the LGBT community. Michael Hardwick was arrested on August 3, 1992. The arresting officer was admitted in Hardwick's home due to his execution of a warrant for failing to appear in court for the charge of public drinking. Just to qualify, uh, Michael Hardwick was arrested on a charge of public drinking, and he was arrested and he was set on a court due date. For some reason, and he was able to pay the fine of $50 already, but for some reason, or just due to clerical error, uh, it did not appear in the records that he already appeared in court and that he already paid the fine. Thus, a warrant was issued against him. The same arresting officer went to his house, which was where he knocked on the house and he was admitted by the roommate of Mr. Michael Hardwick, uh, because he said that he will serve a warrant. While he was uh, inside the house, for some reason, he saw, or while peering through the door, he saw Michael Hardwick in sexual congress with another man. And summarily, uh, seeing this, the officer arrested Michael Hardwick along with his companion and charged them for violating Georgia's anti-sodomy statute. The other pertinent facts of the case. As we contended earlier, as we indicated earlier, Michael Hardwick was arrested on charges of sodomy under Georgia law. However, the district attorney decided not to prosecute Hardwick. If you go to other anecdotes that pertains to this case, it turns out that the man whom Hardwick was sleeping with or that he was having sex with uh, was a married man. In fact, in some sources or in some anecdotes, as I've said, the man was married and he was a teacher, and he actually begged the district attorney not to prosecute him because if this even gets out, it would really ruin his marriage. Although Michael Hardwick was not prosecuted, he decided to file a suit against Georgia, particularly against the Attorney General Bowers at the district court. He he argued that, or he rather alleged that anti-sodomy laws put him in imminent danger of arrest and violated his right to privacy. Again, if you go to other anecdotal records, it was the American Civil Liberties Union who encouraged him to pursue the case. The ACLU saw this as a perfect venue to challenge the anti-sodomy laws of Georgia. Okay, so we now go to the procedural history of the case. As we intimated earlier, Michael Hardwick, through the help of the American Civil Liberties Union, or this ACLU, filed a case with the district court, challenging the constitutionality of the anti-sodomy laws of Georgia. As expected, however, the district court dismissed his case. The basis of the dismissal was on the affirmance of the Supreme Court of the United States of the case of Doe versus the Commonwealth's attorney for the city of Richmond, which is a district court that upheld the state's sodomy laws. Not happy with this, Hardwick elevated his case to the Court of Appeals of the 11th Circuit. The 11th and the Court of Appeals appreciated his case. In fact, it reversed the ruling of the district court on the basis that anti-sodomy statutes violated Hardwick's right to privacy under the Ninth Amendment and the Due Process Clause of the 14th Amendment. And of course, not happy with this, the Attorney General Bowers filed a petition for certiorari, which was granted on November 4, 1985 by the Supreme Court of the United States. The issue that of this case that was recognized by the court was whether the federal constitution confers a fundamental right upon homosexuals to engage in sodomy. So we now go to the ruling of the Supreme Court of the United States, or the SCOTUS, on the petition of certiorari that was filed by Attorney General Bowers on behalf of the state of Georgia. The issue, or the meat of the issue that was asked in the petition that was recognized by the court, was that whether the federal constitution extended the fundamental right for homosexuals to engage in sodomy. The opinion was penned for the majority by Justice Byron White. Um, Sadly, the court ruled that no, the act of consensual sodomy is not protected under the right to privacy, as this right does not extend to the acts of sodomy. In fact, they even invoke the Judeo-Christian traditions that finds acts such as sodomy violative of the 1,000 years of tradition. In this case, it the court narrowly construed on the basis of Christian traditions, uh, that the fact that since the establishment of the states, or the states of the union, each state has enacted laws of sodomy because it is considered an abomination according to the Christian tradition. In fact, one of the justices even equated this, or sodomy, or equated it to the act of rape. So that's how majority of the rulings, um, or majority of the Supreme Court appreciated the case. However, again, as we go, I've indicated earlier, this is one of the most infamous uh, cases that the Supreme Court has decided in recent history. In fact, uh, in this case, it was the dissents. The dissents was the one, or the dissent of the opposing justices was the one that was given merit according to history. All right. So as I indicated earlier, it is the dissents that stood out in the case of Bowers v. Hardwick. And one dissent in particular stood out. It was that of Justice Blackmun. He contended that the ruling of the majority almost obsessively focused on homosexual activity. If we go back to the homosexual laws, it is not confined to homosexuals only. It also included heterosexuals. No? It said that it prohibited people from engaging in sex using the mouth and the anus. The rationality of uh, the sodomy laws is that sex is used mainly for procreation, and it is not to be used, or it should not be engaged in for the pursuit of um, other things, no, other than procreation. Um, Justice Blackmun further contended that sexual intimacy is a sensitive key relationship of human existence. Yes, it might be central to the family and community welfare, and also to the development of human personality. So again, the key word here is that sexual intimacy is a key relationship of human existence. So Justice Blackmun here is saying that sex is not merely confined to procreation or to the establishment of a family. Rather, it is a key component of human experience. All right, it allows individuals, whether um, heterosexual or homosexual, to be able to show uh, love and intimacy with another person or his or her partner. Also, Justice Blackmun contended that this is a case about the most comprehensive of rights and the right most valued by civilized men, namely the right to be alone. The right to be alone means that in a civilized society, man or an individual is given the right to practice his beliefs, the right to practice a way of life that he sees fit for himself, that is individual to himself. Um, this is, according to him, the cornerstone of a civilized society, uh, because one is not limited to, uh, I guess, gender binary roles. And in fact, uh, one characteristic of this dissent that that again is being quoted is that the wording of the word "I dissent." In the tradition of the Supreme Court, or if you read the dissents or of other justices in the history of the U.S. Supreme Court, the wording of "I" contains of a dissent contains "I respectfully dissent." But in this case, or in this very occasion, Justice Blackmun was so abhorred by the decision of the majority that he worded his dissent as "I dissent," meaning that he was sending a strong message that he found the decision a travesty of the ideals of a free society. Okay. So in order to understand or to intimate more or to ruminate more or on the decision of the Supreme Court in the case of Bowers v. Hardwick, it is necessary that we go to the historical context on the situation or the milieu of the world when they decided this case. And we will proceed with this in the next section. All right, so we go to the historical milieu of uh, or what was the world like during the time that the decision in Bowers v. Hardwick was promulgated. So, in 1982 to the earlier part of the 90s, this was the start of the AIDS or the HIV epidemic. Um, in fact, you know, um, AIDS was largely considered the gay man's disease. Well, to be fair, uh, the large number or the large population that was afflicted were those of gay men. This was the time it was also called the gay cancer, and sadly, it was even called a punishment from God for the homosexuals living a life deviating from what the Christian standard of leading a decent life is. And in this case, not much is known about AIDS at this time. In fact, if people are usually diagnosed with AIDS when AIDS was full blown, uh, which eventually led to their deaths. So, uh, hence the stigma of the gay cancer. This was before the time of antiretroviral medicine, which is used to control AIDS, or to prevent HIV from uh, going into full-blown AIDS. In fact, we have reached a point, no, with the technology of ARVs, that ARVs, when taken as prescribed, and when the individual that is afflicted with HIV is able to live a normal life. In fact, viral loads are known to go to undetectable. Essentially, the virus has slept, so it can no longer be transmitted to other partners. And another consideration in the historical milieu that influenced The outcome of the case of Bowers v. Hardwick is the existence of sodomy laws. In 1986, most of the states of the member states of the Union had valid and subsisting anti-sodomy laws. If I'm not mistaken, there were 24, including the District of Columbia at this time. And though sodomy laws were not usually enforced or prosecuted, um, as we saw in the case of Hardwick earlier, no, the DA or the district attorney decided not to pursue the case. However, if we go to uh, the anecdotal history of Hardwick, the arresting officer actually uh, arrested him because it is known that the bar where he works in as a bartender is a gay bar. He actually just threw a bottle in a receptacle, and he was arrested, for drinking. And it is alleged that it was due to him being a homosexual. That's why he irked the ire of that particular officer. Okay, so another factor that influenced the outcome of Bowers v. Hardwick is the constitution of the Supreme Court itself. The Supreme Court then was headed by Justice Warren Earl Burger. So the court then was known as the Burger Court. Uh, Warren Warren Earl Burger was appointed by Richard Nixon, also a known conservative. He was the answer to his predecessor, no, to the predecessor of Earl Burger, which was Justice Earl Warren, who was a progressive. In fact, people say that under Justice Warren, the it wa- the court came under a constitutional revolution because the court or the Supreme Court took a more liberal bent. In fact, during the auspices or the leadership of Justice Earl Warren, the case of Brown v. Board of Education was decided. So the conservatives were crying foul, hence Richard Nixon appointed Warren L. Burger in order to stem the liberal tide that was pervasive in the Supreme Court at this time. So sadly, because of this, it became a factor in the decision why the anti-sodomy laws was not struck down in the case of Bowers versus Hardwick. Okay, so sir, thank you for giving me the opportunity to discuss this case. In fact, I would like to apologize that this video went on such a great length, or I was so long-winded in my exposition. But in a way, the case of Bowers versus Hardwick hits close to home, being an LGBT man myself. And discussing cases like this inspires me to pursue law further. Hopefully, someday, when God willing, I pass the bar, or I graduate from SLU and pass the bar, I will be able to contribute a little to the pursuit of equality or the pursuit of the LGBT rights. Again, sir, thank you and have a good night.